Deputy Federal Public Defender in Los Angeles. I have the privilege to staff a pretrial diversion program there in Los Angeles called CASA, the Conviction and Sentence Alternatives. We have 4 courts in our 3 different divisions of our district, and I also staff our post-conviction drug court called STAR, Substance Treatment and Recovery, Reentry, I should say. So I've been doing that for several years, and you know, like anything else, you know, we learn. There's a growing learning curve. I've learned a lot in the last 6 years that I've been doing that. In the last couple of years, it's the question of what is the future of such programs, not only within the federal system, but of course in the state court system. So we thought that this might be a helpful panel to try to take a look at what to expect, where we've been, where we're at now, and where we're going in terms of problem-solving courts. So I am very, very enthused and honored to have these distinguished panelists. Each one brings some real expertise to the panel. I'll first introduce Dr. Marlowe. Dr. Marlowe is both a lawyer and a PhD in psychology. He's a renowned expert. If you Google his name, you're going to come up probably with 50 pages of things he's written. He's really an expert in the treatment and study of addiction, and with a particular emphasis on drug courts. He's been the chief scientist for the National Association of Drug Court Professionals. Really knows what he's talking about. We're going to start off with Dr. Marlowe, so he can give you an overview, as you can see on the screen, of problem-solving courts in the last 20, 30 years, almost 30 years now that they've been around. And he's also has some experience with federal courts are doing. So, Dr. Marlowe, welcome. Along with him, we're going to have Judge Leifman, who's, did I pronounce that correct? Leifman. I knew I didn't as soon as I said it. So Judge Leifman, who's dedicated his work to mental health courts and services. He's previously a public defender in southern Florida. Has been on the bench and has taken up expertise on providing mental health services for those that are involved in the criminal justice system. Also, he's a renowned speaker. If you were to Google Judge Leifman, you'll see that he's written a number of things and participated in a number of conferences on these issues, and he'll share with us his perspective on problem-solving courts in the mental health arena. One of my heroes, because of his federal experience, of course, is Judge Gleason. Judge Gleason retired from the Eastern District of New York. He's now a partner at Debevoise and Plimpton in New York, doing civil and criminal litigation. I first heard of Judge Gleason when I started doing this work several years back, and he's written some excellent opinions that talk about the value of treatment over incarceration, looking critically at some of the sentencing guidelines and what Congress has done with respect to people who have addiction problems. We will upload a suggested reference list of materials that you might want to look at. I specifically cited 3 or 4 of his more poignant opinions that he wrote while on the bench in the Eastern District. He continues to talk about these issues. It's important to him, and I think he'll bring. I know that he'll bring a great perspective on problem-solving courts and as they apply within the federal criminal justice system. And then last but certainly not least, my colleague Brooke Hyman. She was previously a state public defender in the state of Tennessee, doing problem-solving in a problem-solving court. She and I are co-chairs of 2 of the 3 co-chairs of the Alternatives, Incarceration, and Diversion Committee for the ABA Criminal Justice Section, which I invite each one of you to participate and join, for those that aren't currently. We want to be able to address these issues and others. One of the things we'll talk about briefly as we go through the program is currently we're engaged in developing standards for such courts through the ABA. One of our other task force members is Jonathan Robleski, who's over the Department of Justice, taking a look at the entire spectrum, if you will, of problem-solving courts, from pre-arrest to arrest to filing, post-conviction, those kind of things, and trying to set up standards that all parties and all stakeholders can use. That's a work in progress. That task force is currently meeting, and we hope to have that out in the relatively near future. So without further ado, I'm going to ask Dr. Marlowe to start us off. Thank you for being here. Doctor?
Good morning. I was asked to tell you everything there is to know about problem-solving courts in 15 to 20 minutes at most after sort of 30 years of these programs. So I'm going to be moving somewhat quickly. Obviously, I can only touch the highlights. The first thing I want to say here is, like, when I talk about a problem-solving court, what am I talking about? And sometimes you'll hear the words therapeutic courts or treatment courts, so they're basically referring to the same group of programs. We're talking about people being in a treatment and supervision program as a condition of sentencing or other justice disposition. So it may be a modification of probation condition, it may be a term of sentencing, it may be a guilty plea being held in abeyance in lieu of disposition, but these are criminal cases and programs in the context of that. Therefore, they differ from your hearing about law enforcement deflection, for example, or prosecutor-run programs deflecting people from the justice system into treatment. And that's a critical distinction, and we'll talk about what the research says about that. The emphasis of these programs is on the aims of rehabilitation and specific deterrence. Specific deterrence means getting that individual not to recidivate when they have completed the program. There is a de-emphasis, not ignoring it, but a de-emphasis on the other sentencing goals, so incapacitation, general deterrence, retribution, have secondary importance. They're not irrelevant, but our goal here is not to make an example of somebody. The goal is not a pound for a pound. The goal is to rehabilitate the individual to reduce crime. That's the general concept of therapeutic jurisprudence. Procedural due process in these programs are relaxed. They are not abrogated, despite what some drug courts might think. Individuals waive certain trial rights commensurate with the needs of the program and with the level of jeopardy they're exposed to. So they're waiving their rights to a jury trial. They're waiving their rights to self-incrimination. They're waiving their rights to a speedy trial, but they're not necessarily waiving their right to counsel when facing jeopardy of their liberty interests and other critical constitutional rights that some programs have sort of missed that distinction. Substantive due process remains intact. The conditions of supervision must be rational. They must be reasonably related to rehabilitation goals and to protecting public safety, the nature of the crime. Again, programs that sort of do whatever they want to do without following a rational basis standard are out of compliance with the model. These are multidisciplinary programs. The judge is on the same team with prosecution, defense, probation, and treatment, which, when these programs first came out, was considered to be absurd. We're in an adversarial system. Judges are not on the same team with probation. They're not on the same team with prosecution. But in these programs, they are on a multidisciplinary team. There is frequent contact between the participant and the judge, frequent reviews in court. The judge is considered to be a critical component of the intervention, and the judge is the leader among equals of the treatment team. There is intensive drug testing and other surveillance procedures, graduated incentives and sanctions, so rewards for doing well increase over time, sanctions for doing poorly increase over time in response to infractions, and there is an opportunity to have the plea or the charge vacated or perhaps reduced in severity, or in a post-sentencing program to have the sentence reduced, and also a possibility for record expungement, which obviously the record is not literally erased, but it allows the person to respond truthfully on an employment application or something like that, that they were not arrested or convicted for that offense to avoid collateral consequences. Research on these programs follows several generations. The first question is effectiveness. Do these programs work, yes or no? If they don't work on average, there's no point going forward. The next question, if they pass that first question, is are they cost effective? Does the amount of money they save by reducing crime and increasing employment, having other positive gains, at least make up for or exceed the investment cost of the program? And if the answer is no, unfortunately, from a policy perspective, these programs may not be funded, even if they're effective, if the costs are prohibitive. The next question is target population. Who do they work for? There is no such thing as a program that works for everybody. And anybody who says to you which is better, law enforcement, deflection, or drug courts, has no idea what they are talking about. That is like comparing aspirin to chemotherapy. Okay, which is better? Well, that depends on the nature of the disorder, on the severity, the prognosis, the acuity of the disorder. Best practices, what makes the programs more effective? How frequently should you drug test? How frequently should people appear in court? How should sanction incentives be applied? What kind of treatment should be delivered? And programs that do it right have bigger effects than programs that do it poorly. And so the differences between effective and ineffective programs we call best practices. The next question, mediation. This is testing theories about what is it about drug court that makes them work. Is it because participants are developing a better therapeutic alliance with the powerful judge? Is it because you're simply increasing exposure to treatment? Is it because you're using behavior modification techniques to reward good behavior and punish bad behavior? What exactly is it that's happening? We call that mediation. And then implementation or translation research is, once we figure out how to make something work right, how do we get it to work in practice? How do we bottle it and sell it so that when you go to the drug court in your county, it's doing all the things the research says it ought to be doing? And that is probably the biggest challenge of all. I'm going to show you that adult drug courts, the original model for adult criminal drug courts, have been shown effective, cost-effective. The target population is reliably known, and best practices, not all of them obviously, but many of them have been firmly established. We don't know a lot about mediation, and we have not been able to get to the point of getting drug courts out there in practice necessarily to apply the best practices, and that's our biggest problem. Right now, you're looking at what are called meta-analyses. Meta-analyses are when researchers who have nothing to do with drug courts, they couldn't care less if drug courts work or don't. Their only job is to review all the studies that have ever been done on drug courts, throw out the poor quality studies, and about 80% of studies are so poorly done, they're thrown out as being irrelevant. They keep about 20% of those studies, and they average the effect of drug courts to get the average, most conservative effect. You can see here the studies that were done, the institutions that did them, the number of drug courts that were included in those meta-analyses, and the average reduction in rearrests typically measured over a 2-year period. We generally look at rearrest rates generally about 2 years, mostly because that is where most people are funded. They're funded to follow participants for 2 years. Also, we have found that 2 years is about the average attention span of a legislator. And if you can't get positive effects in 2 years, it doesn't matter if the program works. It ain't going to be capped, it ain't going to be funded. The most recent ones, the biggest ones that have been done, the ones that are most cited, are the Mitchell et al., which is the Campbell Collaborative, and Rempel et al., which was the national NIJ studies. And there you have your average reduction in arrests for drug courts, about 12 to 13%. That's about, on average, how much drug courts reduce rearrest rates. However, some drug courts reduce rearrest rates by 50 to 80%, and some drug courts increase arrest rates by 15 to 20%. This is just an average. The question is what separates those programs. Here you're looking at a national study of drug use. They track down the participants 18 months after drug court, and they do a saliva test to see what drugs are on board, and you can find that 46% of non-drug court participants test positive 18 months out versus 29% for the drug court participants. So again, a reduction in drug use, not just crime, out 18 months. However, anybody who tells you we've wiped out drug use in the population isn't really looking at the data. Much of those positive drug tests were related to marijuana. That does not necessarily mean that that's in fact all they're using, because marijuana remains detectable in the system longer than other drugs. So we may just be catching the drug that stays on board longer. It doesn't mean that's all they're necessarily using. Incarceration rates, the average reincarceration rate in our criminal justice system is 50%. You can expect 50% of individuals convicted of a felony offense will be incarcerated within 3 years, okay? About 75% will be arrested, and about 50% will be returned to custody. For drug court participants, it's about 42% and 38%, so there is a reduction in incarceration rates. I will also acknowledge, however, that there may not be a reduction in incarceration usage. And what that means is the number of days people are actually in jail and prison. Why? Because participants who don't succeed in drug court, many of them are getting more severe sentences afterwards. And so that extra sentence for the ones who fail might be basically balancing out the avoidance of incarceration for the ones who succeed. Not entirely clear what jail beds are actually being saved. Open question. Who should be in drug courts? The earliest drug courts were for first-time offenders. We wanted to get people who were low level, low risk. What you're looking at here is that if you look at all subjects in drug courts, 8% reduction in recidivism for the earliest drug courts. Back in the 80s and 90s, drug courts reduced crime about 8%. The researchers then looked, now it's about 12, 13%. The researchers looked at the participants who had, this was their first offense, no prior criminal history, 5% reduction in crime. Looked at the one with a recidivist criminal history, 10% reduction in crime. So you get twice the reduction in crime when you take repeat offenders, even though the original drug courts were taking first-time offenders. Now, this doesn't make sense. Aren't repeat offenders harder to treat than first-time? Of course they are. But the point is, most first-time offenders are never going to repeat the crime anyway, and so they would be fine if you just sent them to treatment or put them on probation or pretrial diversion. Drug court doesn't do that much better. But when you start taking the recidivist ones who've already shown that a diversion to treatment doesn't do it for them, that's when drug courts get the big effects. So that's why when people tell you we should be doing law enforcement deflection, well, okay, fine, but for the 40 or 60 or 80% of people deflected who are back in the system with a new offense, if law enforcement deflection didn't work the last time, maybe those are the cases that should be ratcheted up into a more substantial intervention. High risk is the term we use. Drug courts that only take drug charges. The original drug courts only took drug possession cases. Drug courts that take drug possession cases, 21% reduction in crime. Drug courts that took theft, forgery, felony cases in which drug addiction was fueling the criminal activity, a 41% reduction in crime. Twice the effects when you don't limit yourself to drug possession. So again, drug courts are not for first-time drug possession cases. They are for recidivist, high-risk, antisocial cases fueled or exacerbated by addiction, high risk. Drug courts that exclude people with mental health problems. Their average cost effectiveness in this case is 21% net cost benefit versus a 37% cost benefit ratio when they take more seriously disordered, more seriously disturbed individuals. So drug courts are like the emergency room in a hospital. They are like the ICU in a hospital. They're where the cases that are assessed and can't be dealt with on an outpatient basis. They're the ones that have to be triaged into the more intensive interventions, high risk and high need. What about best practices? Should the drug court team get together and talk about the cases before court? Should the judge be hearing from probation, treatment, prosecutor, defense, and the team working together? The answer is drug courts in which the team meets to discuss the case prior to court, 40% net cost benefit, mostly as a result of recidivism reduction, versus 19% when the team does not meet to discuss the cases. Twice the cost benefit, twice the reduction in recidivism when they function as a team. When the judge hears from everybody about what's going on with this case and what we should do about it. So the whole idea that we should be protecting confidentiality and that the judge shouldn't be getting ex parte communications, things like that, is wrong from an efficacy standpoint. The more information the judge gets from the team, the better the effects in reducing recidivism and rehabilitation. How often should the judge meet with participants? Every 2 weeks or more often until the case stabilizes. The most powerful effect in drug courts are for frequent court appearances. Individuals who see the judge every 2 weeks or every week have far better outcomes than participants that see the judge on a monthly basis or less frequently. So anybody who says the judge is not critical to this, anybody who says this shouldn't be a court-based intervention for high-risk, high-needs individuals does not know what the research says. These are the results of randomized controlled trials. We randomly assigned individuals to more frequent court sessions, less frequent court sessions, and an ethics board had to stop my study when I did that on ethical grounds because the participants who were not seeing the judge every 2 weeks were doing so poorly it was no longer ethical to have an infrequent schedule of court reviews. Now, of course, if the judge looks like the judge in the picture, the average effects on crime are negligible. We have found that when independent raters rate the judge on fairness, support, optimistic statements, giving the person a chance to explain their side of the story, you get an average of roughly around 4 crimes reduced on average per person. When the judge doesn't listen to the individual, when the judge is nasty, when the judge is punitive, you get roughly less than reduction of basically no reduction in criminal activity. So judicial interaction is critically important. Individual counseling. We have found that if you are not doing counseling in these programs, you have no impact on crime reduction. Now, we all know that the substance abuse treatment system in this country is primarily group-based. If you don't know that, let me tell you that. Most of the services, when you send people to drug treatment, 90% of the interactions they have are going to be in a group. And what we are finding is that does not give the treatment providers the opportunity to deal with the specific problems their participants are coming with. And so when you have individuals getting individual counseling from a skilled clinician, you get an average of 4 less crimes per person. And when they are not involved in individual therapy, it's about 1 crime per person. So this over-reliance on group-based interventions for high-risk, high-needs populations is unwarranted, even though it is the standard of care. Legal leverage. The most important and most powerful impact on drug courts is what happens to you if you fail drug court. If you fail drug court and you just go back into the system and the case continues through the system, or if you fail drug court and you go on probation, where you get less service than you would have in drug court, and you know that that's the alternative sentence, there's no effect or virtually no effect on the intervention. When you are facing a felony count and a likely jail or prison sentence, that's when drug courts get their bang for the buck. Drug courts work for felony cases. They generally do not work or work much less for misdemeanor cases. So current criminal justice reform initiatives that are taking drug offenses and turning them from felonies to misdemeanors are making those cases basically non-amenable to drug court interventions. So the higher risk recidivist cases, the ones with the highest levels of addiction and the greatest likelihood of recidivism, the leverage on those cases is being reduced and their outcomes are going down precipitously, okay? So it is undermining the intervention. Jail sanctions. How long should jail sanctions go? Here we're looking at drug courts that use different lengths of jail sanctions. Some drug courts that only use a day, some use 2 days, some 3 to 6, down to drug courts that send people away for weeks on jail sanctions. And what you can see is that at first the jail sanctions begin to increase a little bit in terms of their effects on recidivism, but then after about 3 days, look what happens. The longer the jail sanction, the less the effects on recidivism. And what does a negative effect on recidivism mean? It means recidivism is going up. Once you go below the 0%, you're increasing recidivism. So drug courts that are giving people a week, 2 weeks, 3 weeks in jail are raising recidivism rates in the population. Somewhere around 3 to 6 days, you can see that line there, that's when the positive effects disappear and the negative effects take over, which tells us that jail sanctions ideally should be no more than 3 to 6 days in length and build up to 3 to 6 days, so 24-hour, 48. Drug courts that are using jail weeks at a time, drug courts that are using jail to quote-unquote detox their participants for a month are actually raising recidivism rates in their community. They're harmful, and they should change their practices or cease operations. And that's our position. This is what we've done. We have something called the Drug Court Best Practice Standards. That's just volume 1 you're seeing. There are 2 volumes. These are published. You can download these from our websites. All of the research on what drug courts should and should not be doing is in those standards with clear statements about what drug courts should do, should not do, and all the research supporting those standards are in the commentary. So if you're dealing with a drug court that's giving people 3-week jail sanctions, or only using group therapy, or having status reviews every 6 weeks, you can show them the standard which says the standard of care is status reviews every 2 weeks, individual counseling, jail sanctions no more than 3 to 6 days. And if you are defense counsel, you can also challenge those practices with the standard of care being the standard of the National Drug Court Organization. So you don't have to make a constitutional argument. You don't have to make a statutory argument. You simply say they're not following their own standard of care. That's the purpose of these standards. Very quickly, and I know time's running out, very quickly, when it comes to DWI courts, DUI, driving under the influence courts, we have the same outcomes for effectiveness, cost effectiveness, target population, okay? And let me say this. For every kind of problem-solving court that has ever been studied, the lessons have been exactly the same as adult courts. No differences. Most of these other courts have not been studied, but whenever a study has been done, there is no difference in outcomes. No matter what people tell you that our program is different, that is never borne out. So DWI courts, almost the same exact effects on recidivism, same exact target population. Recidivist cases, addicted but also have high criminal justice involvement, and fueled by obviously by addiction. And the best practices are looking exactly the same. Status reviews, drug testing, all that coming out exactly the same for that population. Family drug courts, child abuse and neglect cases, effectiveness and cost effectiveness is the same. When it comes to target population, it looks like it's the same. We think you're looking for women, mostly women in these programs, who have multiple child abuse and neglect cases. It looks like you're looking for women with prior treatment failures. It looks like you're looking for women with criminal justice involvement. They're the ones who seem to get the best effect in the drug court model as opposed to just a treatment diversion. Mental health courts, we know a little bit about best practices and effectiveness looking about the same. We have very little information on target population and cost effectiveness, unfortunately. But everything we're seeing is coming out the same. Any other problem-solving court, we have no idea whether it works or doesn't, okay? Doesn't mean it doesn't, doesn't mean it does. Veterans courts, what are some other ones? Homeless courts, gun courts, prostitution courts, domestic violence courts. We have none of this information for any of those programs, okay? None whatsoever. The one program we do have information on is juvenile drug courts, and they are failing disgracefully, okay? Why are they failing disgracefully? Because they have completely ignored every lesson from the literature. They serve low-level, low-risk kids. They don't deliver intensive supervision. They don't do intensive drug testing. They have basically violate all of these components and feel that they should because children are different than adults. So they have a sort of a philosophical view about it. And as a result, the average effect of juvenile drug courts is negligible, basically zero. That doesn't mean that there aren't some juvenile drug courts out there that are doing quite well, but they're a minority, and they're wiped out by all the ones that are not. Very quickly, and I'll shut up, our biggest challenges currently, we'll talk more about this in the session, the opioid epidemic and resistance to or ignorance of medication-assisted treatment is a big issue in drug courts. Drug courts, about half of drug courts accept medication-assisted treatment, and about half, well, I should say as of 2012, about half used it, half did not. And we are working very hard to get those numbers up. It's probably more about 70% use it now and 30% do not. But of the 70% that use it, many of them will say we'll use Vivitrol, so a blockade medication. but we won't allow methadone or buprenorphine, which are themselves opioids. So you've got these courts still sort of practicing medicine without a license, being resistant to evidence-based treatment. The other issue is that the opioid populations coming in, many of these are people who got addicted to a prescription. These are non-criminologically oriented people who got addicted, and their criminal justice involvement is fueled by their opioid addiction. Those are not drug court cases. Those are diversion cases. Those are deflection cases because they're low risk from a criminal population. But I don't want you to buy the argument being made by a lot of the people out there that therefore every opioid addicted individual should go to a deflection program. Because all those high-risk, seriously addicted, antisocial people, they never went away. They're still there also. And they are not appropriate for deflection to the medical system. Those are problem-solving court cases, and figuring out who goes where is the issue. The reduced leverage and deinstitutionalization of the criminal justice system. We are now in a period of saying the criminal justice system is bad, the medical system is good. We need to reduce the criminal justice system, right? We need to reduce the reach of the police. We need to reduce the sentences that can lead to jail or prison. We need to reduce felonies to misdemeanors, misdemeanors to summaries. We are dismantling the criminal justice system very systematically, and we will be deeply sorry for that. Because for the highest risk, highest need people, that's the only thing that keeps those people in treatment and leads them towards rehabilitation. Racial, ethnic, and gender disparities. This is probably our #1 problem in drug courts. There are big differences in completion rates for racial and ethnic individuals, and we are working very hard to get the drug court field to address that problem. There are many people that will say, therefore, we shouldn't have drug courts, and that's okay, fine, but show me any treatment and any program in the criminal justice system that doesn't have racial and ethnic disparities. In other words, we have to fix the programs, not just dismantle them and think that the status quo somehow will be better. And then maintaining fidelity to the model. We got to get programs to follow these best practices, and they're not. There are drug courts in your communities doing everything wrong and calling themselves drug courts. And that's why you need the standards to hold them accountable. Drug courts believe in holding our participants accountable. We need to hold them accountable. And then I already mentioned models slip. Juvenile drug courts are simply not working. And other drug court programs, other problem-solving court programs have basically said, all that research you guys did doesn't apply to us. The biggest offenders right now, in my mind, are veterans treatment courts that think that veterans are just completely different human beings from everybody else, and there's no lessons to be learned from the scientific community. And I suspect veterans treatment courts are going to be very questionable in their outcomes when we actually do the correct research on those programs. So we need to move forward towards accountability. Sorry it took me so long. Thank you.
Thank you. We'll have questions for Dr. Marlowe.
I want to thank Doug Marlowe for the amazing work that he's done. My Florida Supreme Court recently adopted drug court standards, and much of it was based on your wonderful best practice standards, so thank you. I will tell you that when I became a judge, I had no idea I was becoming the gatekeeper to the largest psychiatric facility in the state of Florida. And sadly, that is the Miami-Dade County Jail. While the United States has 5% of the world's population, we have 25% of the world's inmates. As we sit here this morning, 1 out of 104 adults in the United States are behind bars, and 1 out of 33 adults in the United States are under correctional supervision. It's ridiculous. And as you peel back, what you're going to find, in fact, before I get there, since 1980, the number of people going to jail in the United States has tripled, and their sentences have increased by 166%. And as you peel back, as you try to figure out what in the heck has happened, what you will find is most of this is due to untreated mental health disorders and substance use disorders. In fact, people in the United States with mental illnesses are 9 times more likely to be incarcerated than hospitalized. They are 18 times more likely to find a bed in the criminal justice system than at any state civil hospital. Last year, there were more than 2 million incidents involving about 1.5 million people getting arrested with serious mental illnesses, And on any given day, there are approximately 550,000 people with serious mental illnesses in jails and prisons, and another 900,000 under some type of correctional control. 40% of all people with serious mental illnesses in this country at some point in their life will come into contact with the criminal justice system. This is a shameful American tragedy, and it is one that must and can be reversed. Financially, it is also an absurdity. Our counties right now, last year, spent over $80 billion in correctional costs, and the state spent an additional $71 billion in prison costs. It's gotten so bad for counties, they are now having to decide, do we build a new jail or a new school, a new jail or a new hospital, or a new road or a new jail? In my own state, while the prison population has leveled off like most states, the mental health population within the prison population has continued to grow in a huge, huge way. In fact, while the prison population has grown by about 56% over the last 12 years, the mental health population has grown by about 156%. And the crimes that these individuals are often committing are not high offenses. In fact, the average stay for someone with a serious mental illness in a prison is only 2.5 to 4 years. It's usually because of sentencing guidelines, they get swept up, they've accumulated a series of points, and they end up in the prison system as opposed to the local county jail. In Florida, our system is growing so fast that if we don't do something immediately to curb this growth, Florida will need to build 10 new prisons over the next 10 years just for its mental health population. The cost to build 10 new prisons in Florida and operate them for over 10 years is over $2.5 billion. I mean, it's really a shameful mark on our society that we're willing to spend more money to incarcerate people that are ill than to treat them. And then there's competency restoration. We are still using the same system today for competency restoration that was put into place over 50 years ago. 50 years ago, there were a handful of people with serious mental illnesses in the criminal justice system, so it made sense. Competency restoration, yes, is a very important concept. We all have a Fifth Amendment right to a fair trial, and in order to do that, you need to be competent to stand trial. But the problem is when you have about 2 million incidents a year involving people with serious mental illnesses, it's putting an enormous pressure on the system, and we're still using the same system that has a horrible, horrible outcome. In fact, one of the problems is that in some ways, competency restoration is contributing to the criminalization of people with mental illnesses, because you are entitled to competency restoration. The states have no choice but to fund competency restoration if you're incompetent to stand trial. The states do have a choice, unfortunately, because services in the community are not an entitlement. So what the states have been doing over the last 10 to 15 years is they're taking service dollars out of the community providers' hands because nobody raises taxes, and they're funding the massive growth in the competency restoration system. And so as they do that, people have less and less access to services in the community, and more are getting pushed into the criminal justice system. And I'll give you the classic example, which is Florida. The states right now are spending billions of dollars in competency restoration. In Florida, we spend 22% of our entire adult mental health budget to restore competency for about 3,000 people a year. While at the same time, we have between 150 and 160,000 people who at the time of their arrest need acute mental health care treatment. Now, again, if this population that they were restoring had committed heinous offenses and needed to go to prison, that would be one thing. But for 70% of the people that we are restoring in Florida, 3 things happen to them. Either the charges are dropped, they get credit for time served, or they get probation, and under all 3 scenarios, they leave the courthouse with very little, if any, access to treatment. It is actually the definition of insanity, where we keep doing the same thing again and again with very poor outcomes, and nothing has changes. And I will tell you, frankly, the courts are partially responsible for this problem because they are frustrated. There are not services out in the community, and so we misuse the competency restoration system as a service system when it really is not. And it's putting enormous pressure on the taxpayers with very poor outcomes, and it's doing nothing to fix the problem. Just real quickly before I go in and talk about the role of the problem-solving courts and how to fix this, it's really important to understand a few facts about people with mental illnesses. Number one is they are no more dangerous than the general population. Number two, they are much more likely to be victims of violent crimes than perpetrators of violent crimes. And on medication, people with serious mental illnesses are actually much less dangerous than the general population. So maybe we should put it in the water like fluoride. Recovery rates for people with mental illnesses are much better than for people with heart disease and diabetes. Recovery rates are very good, and so it's not a lost cause. People can do very well, and like any illness, the earlier we catch it, the earlier we treat it, the better outcomes we're going to get. So the answer to me is not to establish mental health courts in a vacuum. They are a very small part of how to fix this problem. And part of the reason is mental health courts on their own generally take too few people to really make a dent in the problem. Nationally, only about 0.1% of people with a serious mental illness that end up in the criminal justice system end up in a mental health court. And the 0.1% that do end up in the criminal justice, in a mental health court, are the wrong 0.1%. They are generally the low-risk, low-need individual where the data shows us that if they just go back to the community, into their provider, they're going to do fine. In fact, about 85% of people with serious mental illnesses that are low-risk, low-need will not reoffend if they just get diverted into the community system. The data also shows us, because the courts tend to hold on to this population longer than they should, if it's not done right, they generally end up spending more time in jail if they had just gone back to the community with services. And then the other problem is, and Doug mentioned this as well, you tend to integrate low-risk individuals with high-risk individuals. And so what happens is the low-risk person, which means that they are low-risk to reoffend, don't necessarily teach the good habits to the high-risk individuals. They become friends, and the high-risk person gets a new criminal buddy and gets them further involved in the criminal justice system. In addition, unlike drug courts, rewards and sanctions don't always work well for people with a serious mental illness. Reincarcerating someone who is seriously ill often re-traumatizes them. Now, trauma is a physiological issue. It is not an emotional issue. And so what happens for people with serious mental illnesses often, they've had a really serious traumatic experience in their life. Their brain activity has been permanently altered. They have severe PTSD and other trauma-related illnesses, and reincarceration can make things more difficult and more likely that they'll reoffend and not get into recovery. In fact, 92% of all the women in jail in prisons in the United States with serious mental illnesses were sexually abused as children. They have very severe trauma. 75% of men in jail and prisons with very serious mental illnesses also have very serious trauma history. So what is the answer? The answer is to divert people with serious mental illnesses in both pre- and post-arrest programs, including competency restoration for misdemeanors and nonviolent felonies, which is very consistent with the new American Bar Association Criminal Justice Mental Health Standards. If you look at Standard 7.1.2, it talks about when appropriate, services should be configured to divert people with mental disorders from arrest and criminal prosecution into treatment consistent with the diversion standards. So for us, where do you start? Unfortunately, what makes this such a complex problem is most of the community mental health systems are local. And so there's not a federal or state switch that you can flip on that's going to fix this problem overnight. And so there's over 3,000 counties in the United States, and as they say, if you've seen one county, you've seen one county. And each mental health system within that county is different, and the quality of care within that community can be incredibly different, even providers. There's not a lot of consistency. Unfortunately, mental health treatment is often the stepchild of healthcare in this country. The dollars are inadequate, insurance is inadequate, and the standard of care that is provided at the community level often does not match what we actually know works for individuals with these serious individuals. However, working with the community and providing a better network of care and a collaboration is really what you need to do. In 2000, after a terrible case I had, which involved a psychiatrist from Harvard who had a late onset of schizophrenia, was a defendant in my court, we actually put together a summit in Miami. And I guess one of the best things about being a judge is people come to your meetings even if they don't want to come. And so what we did is I invited all the traditional and non-traditional stakeholders in my community to come and sit down for a couple days and see how we could make a difference addressing this problem. My age directly corresponds to the deinstitutionalization movement in this country. When I was an assistant public defender, I was the acting chief of the county court division in Miami. And in 1 year, we went from basically having no defendants, no clients with serious mental illnesses, to hundreds. And it was because the local state hospital had been closed. And when I became a judge, the situation had even become worse. And so what we did is we brought all these people into the room and we literally mapped out how the criminal justice system intersected with the community mental health system. And what we found is it did not. We were embarrassingly dysfunctional. I remember vividly looking around the room and all of these so-called policymakers, we realized who was more sick. Us folks had designed a system that was actually designed to fail, or these poor folks that were just sick. And so what we decided to do is we needed to do a two-part system. And if I were to do it again, it would have been a three-part system. We produced a series of goals, and we did it based upon one of the experts that we had leading this event from Seattle. They took a group of folks like you to a local park in Seattle, and they took their shoes and their wallets and their purses and their IDs. And they said, okay, you have a serious mental illness. Tomorrow morning at 9, you need to be in court. At 10:30, you need to see your probation officer. At noon, your psychiatrist. And at 2 o'clock, go pick up your medication. And what you realize is that we never created a system for people that were sick. And then we punish them when they don't act the way we want them to behave, when we never offer them the services they need to begin with. And so we knew we needed to develop a system of care that worked for people that were ill. And so we created a cooperative agreement. We actually had a signing ceremony where we made all the different institutions in my community commit to making structural change on how to approach this. We had a couple grand jury reports look at this issue as well. And we came up with a simple goal that read, diversion and linkages to comprehensive care makes jail the last resort. And what we did is we realized we needed to have a pre- and post-arrest system. At the time we started this project, there were about 118,000 arrests in Miami-Dade. A large percentage of this population had serious mental illnesses. And so we started to go around to the different police agencies. I have 36 departments in Miami-Dade. They all have their own culture, and the last thing they wanted was some civilian judge to tell them how to do their job. But with the assistance of our state attorney and some grand jury reports that basically almost indicted their behavior, because at the time we had 2 shootings a month of people with mental illnesses, 1 a month fatal. And so things were really out of control, and we needed to change our practice. And so at this point now, we have the largest trained squad in the United States of what's called CIT officers. It stands for Crisis Intervention Team Policing. It is a 40-hour training program that teaches our law enforcement how to identify people that are in crisis, how to de-escalate, and where to take them as opposed to arresting them. We keep data now on every single call my 2 largest agencies, the City of Miami and Miami-Dade County, make in the mental health field. Between 2010 through 2017, the City of Miami and Miami-Dade combined handled 83,427 mental health calls. It is stunning. But what's more impressive, out of those 83,427 calls, they only made 149 arrests. So our arrest rate in Dade County, the number of arrests went from 118,000 to 56,000 this year. It enabled us to close one of our 3 main jails. And when people talk about savings, it's usually intellectually dishonest, because if you take 500 people out of a jail and don't close it, it doesn't really change the cost. But when you actually close a jail, for us, it was a $12 million a year savings, which we've been able to get the county to reinvest in new services and a new facility we're building just for this population. Also, police injuries almost stopped. Police shootings almost stopped. Because one of the things that we found that we had not even anticipated was the level of PTSD among our police officers. They have very severe PTSD. In fact, last year, more officers died from suicide than in the line of duty. They have high suicide rates, domestic violence rates, substance use rates, and suicide rates because of their own mental health disorders. They get 6 to 9 times more cortisol a day because of the stress and trauma that they experience than civilians get. And they are really reticent to go get treatment. So we actually set a treatment program up for our police officers outside their departments to get them help. It helped make them more empathetic, it made them more sympathetic, and now you're the cool officer if you get hit by someone with mental illness and don't make the arrest. You're now the wimp if you go ahead and arrest somebody with a mental illness. The entire culture in our community has changed. But we knew just doing pre-arrest wasn't going to be enough. So we set up 3 post-arrest diversion programs as well. Now if you get arrested in Miami-Dade, because I will tell you, on misdemeanors, we do not have competency in-house restoration in Florida. And so we, in Dade County, we're spending almost $2 million a year just on psychological evaluations on misdemeanors so we could release them back to the street where they would often disappear or reoffend, or the officer would get smarter next time and just arrest them on a felony because they knew they would get more help. So we're spending a couple million a year on evaluations. We have totally stopped that practice. Now if you get arrested in Dade County, and it's usually the people with much more severe mental illness because the police have stopped making arrests on the low-level offenses, you're immediately evaluated at the jail with a validated screening tool. And if you meet criteria for our program and hospitalization, within 3 days of an arrest, you are transferred from the jail by the Department of Corrections to one of our crisis stabilization units. And because they are on a criminal hold, the 72 hours under the civil and voluntary hospitalization laws does not apply. We reset the case in about 2 weeks, which really allows this population to become stable. We then have a team of individuals that goes and meets with them, and we say, look, if you go into our program, you're not going to be rebooked. You're going to come right to the courtroom, and we're going to take care of all your needs. We're going to get your benefits lined up. We're going to get you housing. We're going to get you treatment. We're going to get you clothes, medication, food, whatever you need for recovery. Our recidivism rate dropped from 75% to 20% among our misdemeanor population. The state attorney was so excited about this, she allowed us to expand it to nonviolent felony cases, which we are doing now for the last 5 years as well. The felony program has saved the county almost 6 years of jail, 68 years of jail bed days. The recidivism rate dropped to about 25% over a 2 to 3 year period, and the population is doing much, much better. We also, for the state, set up a competency restoration diversion program. So we're taking people who otherwise would have gone to our in-house competency restoration on nonviolent felony offenses and leaving them in a local lock program where instead of just focusing on restoration, and if you've ever seen how restoration is done, you would cry, it is a joke, we really focus them on reintegrating them back into the community. And once they become more stable, we then put them in our felony diversion program where the court then monitors them for another year, and upon successful completion, the charges are usually actually dropped. And so we don't really need to go through a whole restoration program because they're not going to trial and they're having their charges dropped, and at any time they could go forward to a trial if they so please. That program has seen huge improvements in outcomes. Most of the population is not reoffending that go through that program, and all of this is saving money, it's saving lives, and it's allowing people to get their lives back in order. And so for us, what the court should be doing is helping process these cases and making sure that everybody that needs these services gets these services, and not limiting just to a mental health particular court that really has not made a huge dent in the problem. And our hope is that as we continue to put more pressure on the community system to do a better job, and that we all work together on this issue, we'll finally accomplish what the Supreme Court wanted us to do when deinstitutionalization began. Thank you very much.
Thank you, Judge.
Good morning, afternoon. My name is Brooke Hyman. I currently work with the Memphis City Council. I was previously a public defender at the Shelby County Office of the Public Defender. And so I'm going to speak from a kind of practitioner's point of view and where the future problem-solving courts. So in local jurisdictions, state, or even when you get into the smaller federal portions, always funding is an issue. And the things we've discussed now are what are very helpful in trying to pitch a treatment court, because you have to get buy-in from everyone. So that's a hard thing to do, but also getting that initial buy-in is important because usually you need everybody that you need the buy-in from to make the court successful. And for me as a practitioner, one of the issues that we've had in our courts is the needs assessed and being addressed, and kind of floating the line appropriately and ethically to use a treatment court and to also be a zealous advocate. So one thing that I think is really important is when we're doing this, as treatment courts go, problem-solving courts, there's usually a period of time where someone decides to be entered or not, and I think it's really important, and I can say from my experience, that a defense attorney doesn't put someone in treatment court on a bad case, and a prosecutor doesn't go forward in a treatment court as a bad case, because there are all those options where you could possibly do some type of diversion, but not just pleading someone out for the sake of getting them into a treatment court, which can become very easy when the outcomes in a treatment court seem much better than the penalties that someone would face otherwise without doing the kind of adversarial process. So for me, that's a future that I think has to be addressed, and I don't know that it is all the time, and I'm not sure we've even addressed it in our conversations, ensuring that in going through the treatment court, we're still all being zealous advocates, and everybody's still kind of knowing their role and doing their job, but doing it in a way that promotes partnership that's beneficial for the participant. And I haven't heard anyone say defendant when we're up here, because I think once you enter a treatment court willingly, I think it separates you from just someone that's coming there. You've taken an active role, a lot of times signed a contract, so I'm glad to hear that no one said that, because participant or whatever you would like to call it, but I think it takes a little bit off, and I think that also helps people be more willing to do these treatment courts. But in the funding, one thing that's been discussed is funding general statewide, but also there's been a lot of increases in funding on a federal level for some of the things, especially that the young lady just asked about mental health. So those things have been increased, but I think on a state level, increasing funding and all those things are important, but applying the standards that are set out in a way that makes sense within your jurisdiction is really hard. And so the standards are always the best framework, but I think sometimes where we have the failures in programs are when people just apply a standard that doesn't really fit their jurisdiction appropriately. Always follow standards, but what will work in Washington State may not work in Shelby County. Knowing your population and just targeting your programs to be most effective is really important when you get down to a local and state level. And that's a nuance that's really important for the stakeholders to take in the beginning of evolving a treatment court, which is why I always say having everyone there is very important. And what it also breeds is a partnership. So for me, I left the public defender's office and I work for our city council, and our city council is very separate from the criminal justice system. But we've had more success recently in some of the programs because there's been, across the board participation. And so I also think that's important when you are advocating for a treatment court as an attorney, as a judge, as a practitioner, as a studier. You're not just advocating for the court, but I have to remind myself that you're advocating for the people that most benefit from it as well. And so I think that for us also, our treatment courts in Shelby County are getting a little crowded, and that is not a bad thing, but it also has not been a very deliberate thing. I think we have moved into a realm within our small jurisdictions where if there's a problem, you've got a treatment court. And there is always an innovative way to do that, but I think we have 10 to 12 divisions of court now, and 7 of them are treatment courts that don't necessarily work in a concerted effort to reach a client, because you may end up in a drug treatment court when you should be in a veterans treatment court. And it sometimes now, because there's so many, becomes a race into who gets into the treatment court, who has the best figures. So I think that's also something that needs to be addressed on a state and local level as we move forward with more treatment courts, because that is very good, but that we're using them in a way that's most beneficial and most efficient. And I don't know that that always happens, because a lot of times, as I said, when there's a problem, up comes a problem-solving court. So But I think also one of the futures of it is the kind of, and most importantly, the wraparound services. Treatment courts have come a long way from we're drug testing you and giving you, a small amount of medical attention to looking deeply at what is causing the recidivism and addressing that in your treatment plan. The most effective treatment plans to me aren't just the ones that involve, and this is again for my city that has an issue with poverty as well, is that when we do treatment courts, we're not just treating the scene problem, we're treating the underlying problems as well. And I think that comes from, as we've discussed, having open meetings where everyone can discuss the challenges that are coming with the case in a setting that allows an attorney to be ethical, allows a judge to maintain control of the courtroom, and allows the treatment providers to give their insight. But being able to do that allows a treatment court to work in its best form, because in my experience, treating a drug problem but not treating the underlying trauma from growing up in a very poor neighborhood where you're afraid of police and you're afraid of guns won't get to your drug problem. The person may have a dip in drug use, but not necessarily criminal activity that's fueled by that drug use. So I enjoyed that portion of it, the roundtable conversations, because I think they are very beneficial. So, I'm trying to wrap it up because I know we have more. But I think that one thing I will say is, as we've talked about this and we say there's been jumps in mental health and there's been jumps in veteran issues, these are new problems. I think we're just looking at them differently now than before, because the same issues of mental health and poverty and homelessness that were there before, they're not new. We're just addressing them in a different way, and that's going to be ever evolving and require partnership within our local state courts.
All right, we're going to transition into the federal system, which is obviously a smaller, different system in so many respects that matter when it comes to problem-solving courts. And I'll try to shorten this because I know we're a little short on time. The origin of what I want to speak to you about is an over-incarceration problem that produced this shift from indeterminate to determinate sentencing, produced that prison population explosion in the United States as a whole, and this prison population explosion in the federal system, as a result of which a lot of people in the system started to think about what to do to address what became, I think there's a consensus. We have an over-incarceration problem, and there needs to be something done about it. And back beginning about 6 or 7 years ago in my district, Eastern New York, we started to think about what the solutions were. And one way to put the potential solutions into a couple of buckets is, are there people who need to be imprisoned who are being imprisoned for too long? We're not going to talk about that. That's mandatory minimum reform, excessively harsh guideline reform. But the second part is, and we started to think about this in Brooklyn, are there people we're routinely carting off to federal prison who maybe need not go to prison at all? And giving that some thought produced some inspiration, and this is where the CASA program that Raul alluded to at the outset intersects with the programs that I want to speak to you about. I went in 2011 to the Ninth Circuit Judicial Conference, where there was a program on federal reentry courts, which Dr. Marlowe alluded to briefly. Reentry courts in the federal system aren't exactly ubiquitous, but they're common. After federal inmates complete their prison terms, in many districts, they'll undergo a supervision period, and in many districts you can shorten that period by successfully participating in a federal reentry drug court. And at this Ninth Circuit presentation that I attended about reentry courts, influenced by the movement that Dr. Marlowe has described, and I've been teaching sentencing at NYU for 25 years, so I was familiar with the state drug court movement. I raised my hand and said, well, why are we waiting? If the behavior modification device that is a shortened supervised release term appears to work so well, and there's some dispute about how well it works, but these folks certainly were asserting it worked well. If it works so well to enhance drug treatment retention rates, reduce relapses, reduce recidivism rates, after people get out of prison and all they have to earn is 1 year off a 3-year term, what are we waiting for? Why don't we do this drug court model before they go to prison, adjourn the sentence, and use as a behavior modification tool the prospect of not going to prison at all? And that's when Sean Kennedy, who was then the federal defender in Central California, said, you know, we're working on such a program with the U.S. Attorney. That became the CASA program. The CASA program and these programs in Eastern New York were, as a result, created at roughly the same time period. The POP program is the Pretrial Opportunity Program in Eastern New York. It's a federal no-entry drug court. It's not doesn't wait until someone has been adjudicated guilty and sentenced and served a prison term. The idea is to have the drug court model inserted before the sentencing process could begin in the pretrial, pre-sentence phase, pre-adjudication phase. And then at the same time, we had this supervision model. Back in the early part of this century, the great Jack Weinstein was our chief judge, noticed that there were youthful offenders, younger than 25, coming into the Eastern District, and they weren't getting released pre-trial. And they seemed to fit a pattern. They grew up in a context in which nobody taught them anything. No one gave them structure. No one taught them to go to school, look for work, go to work. And he created what he called a special options services program, an intensive supervision for youthful offenders. And at the same time, we created the POP court, roughly at the same time. I went to the pretrial services officer who was doing the intensive supervision of our youthful offenders and asked her if she thought judge involvement in that intensive supervision program might be useful. She said yes. So we began what are two, I guess we'll call them problem-solving courts. Again, intended to be alternatives to incarceration, not post-incarceration programs. I'll skip this slide. If you want it, you'll tell me. I'll send it to you. It's a couple of opinions I've written and a report to the Board of Judges in the Eastern District of New York. And it also commends to you the drug site, the National Association of Drug Court Professional drug site that Dr. Marlowe knows more about than anyone. It's a very useful resource. The POP program has as its admission requirements charged with a nonviolent crime. There's some wiggle room around the edges of these requirements. Not the second one. There needs to be a documented history of substance abuse. An assessment is made before someone is considered for entry into the program that the events that gave rise to them being in the courthouse as a defendant arose out of their addictions, and we chose not to permit folks who were alleged to have a leadership role in the criminal activity become participants in the program. We're going to skip Emily in the interest of time. And I hope we have audio on this. Let's see. Are you taking care of the audio for me? Thank you, sir. What is your name? Thank you. This is Arthur. Okay. Arthur comes into the program.
We started with
Here we go.
marijuana briefly. It immediately went over to cocaine. Immediately after cocaine, it was crack cocaine for years. I believed in the drug more than I believed in myself. My last stop was federal court.
And that stop was the result of Arthur being arrested in the only marijuana conspiracies that make their way into federal court are large marijuana conspiracies. Arthur was arrested in one. He was one of the original participants in the POP program. He had 13 priors. One was a violent robbery when he was 17. You missed him saying he was 46 when he was arrested. He had a 32-year-old addiction at the time of his arrest. He had been in and out of drug treatment as a younger person and as a middle-aged man. He came into the POP program, had intensive inpatient drug treatment, followed by outpatient drug treatment that was several sessions per week, earned a commercial driver's license, got a job in the city parks department. He's now a supervisor. He served no prison time. I'm going to come back to the dispositions in these programs in a few minutes. He's now been clean for 7 years, for more than 7 years. The eligibility for the SOS program, the Youthful Offender Court, those requirements are 25 years of age or younger, charged with a nonviolent crime, and again, consistent with the pretrial supervision program that existed before it became a judge-involved intensive supervision program. Judgment needs to get made that the offender, the defendant, will benefit from intensive supervision that has the participation of a judge. Here's a typical participant in the SOS program. Let me see, what did we do to get the, did we click on the pause button here?
Growing up, and I lived in the projects or whatever, and it's limited things to idolize. So you idolize all of the negative, those selling drugs, the fancy cars, the respect, and things of that nature. So I gravitated towards that, the gang lifestyle. So I became a gang member at the age of 12. Did a bunch of gang-related things, the fight and the whole shebang, and that's the way I conducted my life until like the age of 19.
When he got locked up on a typical street-level drug distribution charge in eastern New York. The way the process works and the models differ. This is different from the CASA program that Raul is familiar with. When we created the POP program, Loretta Lynch was our United States attorney, and I didn't want to wait to do an interagency agreement as they have in California. I know how to adjourn a sentence on my own. I didn't need the U.S. Attorney's permission to do that, but I went to Loretta and said, we'll be the gatekeeper. The pretrial services officer in charge of the program will be the gatekeeper. Recommendations can be made by the judge in the arraignment court, by defense counsel, by a prosecutor for admission into the programs. But the gatekeeper is the pretrial services officer, as distinct from the interagency committee that really characterizes most of these federal no-entry programs, as in CASA, where there's a committee that consists of a judge and a defender and a prosecutor and a probation officer. What makes them work and what identifies them, what identifies the POP program as a drug court and the SOS program as a judge-involved intensive supervision program are the monthly meetings with judges and other participants and the judges. This is a photograph of a graduation program. Dr. Marlowe referred to the question of what makes them work, and a lot of the educated folks, educated about the state programs, will tell you that what makes them work is the interaction between a participant in a drug court and a person in a position of authority, a judge, where the judge assumes a supportive role, not up on high, wagging a finger and sending them off to prison. I'll go to my grave believing that at least an equally important dimension to these programs and what makes them work is what the participants do for each other around that table during those meetings. They're all in different stages of participation in the program, often in different stages of their recovery. They cajole each other, they yell at each other, they support each other, they love each other. They can relate to each other in ways that no judge could ever hope to be able to relate to them. And what we found in the path of the successful participants was there came a point, and we wished we could find out and kind of bottle what it was that caused people to reach a pivot point. You know, they all wanted to go in because it's an opportunity to avoid going to prison. And as they would describe it, they would just jump through hoops. They would do whatever. They'd wear a pink tutu if they could avoid prison. But then they each got to a point where they decided to devote themselves to it. And there was a level of you could feel it at the particular meeting, where you could sense where they were all of a sudden not doing this because they were told to do it and there was something in it for them, but they decided. And I want you to hear Arthur describe how the other participants in this program meant so much to him.
The POP program,
Thank you.
wow, it took me without my own permission. While I was trying to get out of it, the program was getting in me, you know, and it took me by storm. And one day I just felt like I wanted to change my life. I was 46 years old when I got arrested. I have four children, 2 grandchildren, a wife that wanted to leave me if I didn't stop using. Actually came home one day, the apartment was clear, there was a duffel bag of clothes in the corner, and I still wanted to use. And I just thank God for the program, for the people that was put in front of me from the POP program, because but the people loved me more than I loved myself. And that took me by storm, and it gave me enough time to stay clean. It gave me enough time to realize what the program is trying to do for me. So I had to realize I had to do something for myself. It ain't gonna work without me.
The quid pro quo for successful participation in the CASA program is set forth up front. A couple of tracks. One track, you get a diversion, you get no conviction. Track 2, you get an agreed upon sentence of probation. We didn't do that in Brooklyn, as I mentioned. We didn't do an interagency agreement, but rather I've said to Loretta Lynch, when people successfully participate, the whole point of this is an alternative to incarceration. I'd like you to agree with us that they shouldn't go to prison. I want your prosecutors coming to court and saying they need to be sentenced pursuant to the sentencing guidelines. And she basically saw me and raised me, because what happened with Emily, we skipped over Emily. Emily, another story that'll just warm your heart, was our first successful participant, came into my courtroom to be sentenced. Loretta Lynch sent in her assistant U.S. attorney and said, you don't have to worry about sentencing. She's done so well. We're going to dismiss the charges, turning what was just an alternative to incarceration program into, in part, a diversion program. And I don't have to tell you how important it is not to have a federal conviction once you come out of the process. The outcomes include these 3, where you're sentenced on the original charge. Arthur, for example, had 13 priors. They weren't going to dismiss his charge, but he wasn't sentenced to prison. There can be reduction to misdemeanor. That's actually kind of rare. And the third one is dismiss the charges entirely. Of the 106 total participants, 74 are out of the program. There's a 70% success rate among them. Of the successful ones, 46% have had their charges dismissed. 3 had felony charges reduced to misdemeanors. Only 4 served any prison time at all. This cost savings is measured by reference to saved prison months, and Judge Leifman made a very good point. It's not like the Bureau of Prisons actually saves the money or writes a check to the probation department to pay for officers to do this intensive supervision. And the real cost savings, of course, are not just human, but they're measured by reference to Emily having a job, Arthur having a job, paying taxes, not in prison, not having their children be wards of the state, and the like. These programs, have grown up. This is a real movement. Before I left the bench, we had 12 visits from delegations of judges and prosecutors and defense lawyers and probation lawyers from around the country to Brooklyn. I know CASA receives visits as well. They go back to their own. This is an incomplete list. There are now a total of 24, I think 25 actually, such programs around the country. There are different types of models. They're, you know, all, looks like all politics, all problem-solving courts tend to be local. It depends very much on case mixes. It depends on the types of cases that are brought, other factors as well. I'm going to skip over this because we're short on time. Conventional wisdoms, you know, the federal system is different. And one conventional wisdom we've confronted in speaking to districts without these programs is, you know, enlightened prosecutors, U.S. attorneys have this frequently. It's like, well, this is federal court. You know, we don't have all those cute, simple possession cases. Well, we have El Chapo in our courts. And you don't have to hang around the wells of the federal courtrooms very long to know there's a meaningful number of people like Arthur and like Emily, who is a drug courier. People who are, there's no question that there's a germ of there's a legitimate point there, which is the proportion of the federal caseload amenable to this type of disposition is much smaller than that in the states, but it's meaningful. And the CASA program and these POP and SOS programs, they're now 6, 7 years old, and they capture 5% of the caseload, roughly 4 to 5%. That's a meaningful number of defendants. The other conventional wisdom is this isn't a proper role for judges. You know, not all judges can do this. You know, some judges think it's anathema to the judicial role to be supportive, and you're not going to sit at the table and be supportive of someone that someday you might have to sentence. That's okay. We don't need them. There's plenty of judges, as you could see from that list, that are willing to do this. There's some defenders who can't do this. Some defenders think that the only permissible role for a defender is to be at odds with and never to hold hands with or be in collaboration with prosecutors of the court, and that's fine. This criticism that, you know, I speak a lot about this and was known for supporting this movement on the bench. I never heard this directly, but indirectly I heard this, you know, this criticism that this is like kumbaya court, you know, hug a thug, like this is the easy way out. And the easy way out is really to do what the Sentencing Guidelines Manual tells judges to do, which is they come into court and 97.5% of them plead guilty, and then you sentence them. Arthur would have been sentenced to about 7 years in prison, and then you go on to your next case. That's the easy way out. The hard part is dealing with this is, you know, I have 2 kids of my own. Once I got involved in this endeavor, I felt like I had 20 kids. You know, it breaks your heart when they relapse as part of recovery. Breaking institutional rules, like having a phone in your inpatient drug treatment facility. That breaks a rule. You have to figure out what your graduated sanctions are. This stuff is hard, but it works. Let me hustle to the end here. The Sentencing Commission, basically, despite what is an obvious grassroots movement, there is very little centralized support for this notion among the institutions that make federal sentencing policy. Chief among them, the Sentencing Commission. It really does need to amend the guideline manual to tell judges it's okay to consider a sentence other than incarceration for people who successfully complete a judge-involved intensive supervision program. Commission needs to be a clearinghouse of information about these programs. These things work. I'm going to skip over Ramon. These things work because, as I mentioned earlier, people interact with the criminal justice system that is supportive and forward-looking rather than backward-looking and punitive. And we have to skip him. I'll say this, you know, I was on the bench 22 years, and I felt as though for the first 15 years of it, when I wasn't involved in these programs, I felt like I was doing my job at sentencing. But nothing brings judges closer to the humanity of the people who come before them, or closer to the work of the probation officers and pretrial services officers than involvement in these programs. You understand that people's lives are not siloed. People don't, you know, their lives are not just a criminal justice problem or a family court problem or a landlord-tenant court problem. They have all these problems, and they all act at the same time. And our system tends to be less than holistic, especially the federal system. And interacting with the entire human being that's before you is transformative for judges in a way that is analogous to how transformative it can be for the participants in them. And in that regard, I want to leave you with Arthur. Arthur, as I mentioned, 13 priors, he's 46 years old, big marijuana conspiracy. There is no court in the country in which Arthur could have been brought, other than Eastern New York, where he would not have served at least 5 years in a federal prison, probably longer. And he had this opportunity, and he seized it. And here is Arthur now, 7 years clean, and here is Arthur now. And I started out talking about these programs like the part-time law professor that I am, thinking the way you sell them is you do enough of them and you generate data like they have in the state courts and you prove that they work. And I still believe that. I don't think criminal justice policy ought to be made by anecdotes. But anecdotes can inspire you. And boy, if you need inspiration, just listen to Arthur. Or not.
Today, I'm proud to say I work with New York City Parks Department. I just got promoted supervisor, PS1, getting ready to do a seasonal promotion for the summer. Just wanted to mention that, manager. I'm so grateful for POP program. I've been clean 6 years, 3 months. I'm the head kahuna of the family now. I mean, like, sisters, brothers, cousins, I'm all call for advice and help. At one time, I was the one calling on the phone, do you have any money? Or I need some advice. I'm just grateful. I have a position in life now I need to uphold to help others. It's like, it's become not even about me no more. It's about the children, the grandkids, and the family. And thank God, he allowed me to buy a house in Brooklyn, Canarsie, Brooklyn, 2-family home. I'm actually a landlord now. And when the people moved upstairs, in my mind, I'm saying, wow, at one point, they would be moving right out because I was a drug addict and a thief, And this program gave me so much time to realize you're better than that.
Thank you.
Thank you, Judge. Thank you for your presence here. I'm sorry that we ran over a little bit and I wasn't ahead of the curve for these technological issues, but our panelists will be around. I am going to upload, I mentioned earlier, a list of suggested reference materials, which include information that everybody's mentioned. It should be up in a day or two, but there's a lot of good information, 5 pages of links regarding problem-solving courts. So my information is on there. If you have any questions to follow up on or contact information, please feel free to do so. Again, thank you for your participation, and thank you for our panelists here today.